Testing, testing. Hey, friends. So, we're on after complex. Solano County as an entity. Solano County Child Welfare Department started investigating the plaintiff before jurisdiction was even accepted by the Juvenile Court of Solano County. On the department's court report, Wendy Smith alleges plaintiff was staying with Mr. Talbot at the new residence, which was false. I wouldn't put my kid at risk like that of these monsters. And used false demands, keeping plaintiff from visiting baby K. Ben Worrell approved unsupervised visits during the duration in between counties. Did. He said all that matters is she doesn't live there. Good job keeping them families together, guys. Oh, don't put that in your complaint. Let's see. This demand alone, and without trial or evidence, and the accusations of Roger Rodriguez to the plaintiff's mother, made plaintiff homeless in a new county without any resources. The predetermined bias placed on plaintiff in Solano County caused her to be threatened by Fairfield police several times and has called Fairfield police to assist. Has caused. I knew I didn't call them. Has caused Fairfield police to assist in the legal acquisition of 2 vehicles since. Yep. The Fairfield police were asked to check the legal status of baby K's residence, attempting to cause more harm and stress. The Fairfield Code Enforcement, because of Solano County Child Welfare Department, has been abnormally aggressive in several instances due to the lies and bias formed from Wendy Smith and all other social workers regurgitating Roger Rodriguez's lies. Excerpts below are from motions made by plaintiff to Solano County Juvenile Court and County Council, all done so no parties from the point of submission could deny knowing such facts. Mother Peterson filed a notice of appeal with Solano County Court Clerk due to failure to comply by Solano County Department of Human Services to Rules 512 California Codes. Okay, so just a precursor on this one. They just won't give me any paperwork. We all know this. So this is just like the last time that I finally had to formally tell them what to do, or which I had, but this time there was no excuses that I could think of. Okay, back to the point. On September 22nd, 2019, Mother Peterson filed a notice of appeal with Solano County Court Clerk due to failure to comply by Solano County Department of Human Services to Rules California Codes 512, Code of Civil Procedure, Section 2016.010 through 2036.050, and Family Code Sections 2100 through 2113. Pending sanctions under Rule 3.1348 under the court's discretion. This was in response to noncompliance of giving paperwork requested 6 months prior. Immediately, the department finally responded with an email on 11/22/19. Mother Peterson reviewed and responded to the DHHS Child Welfare Department's email from Ms. Hanson at the front desk of Solano County Office on Beck Avenue, Fairfield, California, in regards to her file requested on April 5th, 2019. Mother Peterson's response via email was to whether the litigation package was in the bunch. Ms. Hanson responded due to privacy, she did not know what's in it. Mother Peterson picked up the file the following day and refused to sign a prepared form that stated she picked up the entire requested forms. They're hoping I was being dumb. The litigation package and many other requested and filed with the court documents were not included. Mother Peterson did receive the test notes and several other items not disclosed before. Included was a lab report and MRO notes. On the Quest Diagnostic Lab report, it clearly states test in question. The lab report notes state no test / tests are indicated on the custody and control form for the specimen submitted. Please clarify the testing required and fax it to 872-222-3580. Please be advised that the specimen will be discarded if no reply is received within 7 days. Number 1. No fax follows this in the file. It's printed on it with the same timestamp of the Department of HS and Quest letterhead with the wrong icon. On the MRO case notes, the mysterious case number appears like pointed out in many of Mother Peterson's declarations to the court and department. 2017-914 14968 was on the CDAT result print out, not disclosed until habeas corpus pleadings on my son's birthday, 10/30/18. The chain of custody was broken when, in MRO notes, parents were not made accessible to the MRO. The MRO clearly marks a test negative, according to the company. If the client was not able to clarify abnormalities, Jason Tasteides, an actual convicted criminal, I did a background check, told MRO donor is a 1-year-old, no auth, to speak to parents. This never occurred. Had the MRO talked to either parent or asked for medical records, the test would have been deemed negative. Mother Peterson called I3 MRO and Cindy informed her the entire file was requested in December of 2017 and they have nothing. Jason Tasteides admit he is not a qualified expert or a toxicologist. He only certifies as a test taker, sample taker, whatever. Bisniver. 2 of the scan bars on the Quest lab form do not scan. I am demanding the 3rd Thanksgiving without my children because of this court to end this immediately. Mediation should have been given years ago in this matter, but the department has a vendetta against me. But I said, Mother Peterson, that is hurting the children, that in which they are supposed to be preventing. A parent cannot do services without admission of guilt to a crime not committed. Extension nonprofits. Oh, wait, I skipped a line. My bad. A parent can't do services without admission of guilt to a crime not committed, which is brutality and assault with collusion amongst all county agencies and extension nonprofits. These parties play an ice cream cone that licks itself, as Tom Fenton would say from Judicial Watch. KT was not in the physical condition stated by both departments during birth. KT was healthy 1 month before Sacramento's illegal invasion and seizure, per our doctor's records. KT was healthy during her time with father prior to Solano's seizure. Both counties have reached beyond their scope and authority in American-funded society. KT does show separation anxiety when separated from both parents after visits. She still does. It is in the best interest of KT to be released to her parents immediately. That was one of the motions I submitted. Another motion stated, facts. Father Talbot nor Desiree Peterson has any charges of drug use with the law, nor any other legal reasons for such warrants to be requested or granted. Argument. The social workers are under the color of law, so such applies to them also. Officers who applied for a search warrant were acting in the state and county's law enforcement. Officers investigating state law violations. Here, the officers who were investigating activities in Talbot's homes seized Baby K for a second time when Solano County Court judges, social workers, investigators, and county council were clearly state officers and workers were not pursuing possible violations of state law. The deputies were not working with the federal law enforcement agencies, did not indicate in the affidavit that they were pursuing a violation of federal law, and did not seek a federal search warrant from a federal magistrate, or otherwise comply with federal R criminal law, page 41. Therefore, the search was illegal under the Fourth Amendment, unless the facts set forth in the affidavit establish probable cause for a violation of state law, regardless of whether there was probable cause to establish a violation of federal law. So that is the argument against them. Yeah, they weren't pursuing any violations of law. So what the hell are they doing in our houses? Knocking that out.